What is tort reform in Texas? This is a challenging topic from plaintiff's attorney's perspective because we don't like tort reform, and I think for very good reasons. Tort reform is really a decades-long effort to enact legislative changes that limit the ability of plaintiffs to recover compensation or to be made whole or to find justice after an injury. So this primarily affects personal injury and medical malpractice cases. Most of the reforms that are sought on behalf of insurance companies or corporations, and there would be caps on damages, both economic and non-economic damages. What I mean by economic damages would be financial losses, lost wages, or incurred medical expenses. Non-economic damages would be things like pain and suffering, mental anguish, physical impairment, the sort of intangible damages that absolutely are critical to anybody's case. Really, I think most of the time, the real more important pieces. Now, it's easy to calculate medical expenses. It's difficult to calculate pain and suffering. But I would argue that pain and suffering and mental anguish, physical impairment, those are the much more dramatic effects over people's lives. Bills, obviously, financial stress, obviously, those can be stressful. But when you just can't do things any longer due to an injury that you sustained by no fault of your own, that's a dramatic effect on your life, your relationships, and it can lead to ripple effects that have consequences for decades to come, for the rest of people's lives. And what tort reform does is try to limit recovery for these things. Have, hundreds of thousands in medical bills, but you might also have your life affected in a way where you just can't do things that you used to do anymore. They might be small things, but they might be large things. Our position at Ellis Thomas, and I think most plaintiffs' attorneys, is that there should not be efforts to arbitrarily limit what a plaintiff's recovery could be or limit what their damages are. Despite how bad these damages are, we're only going to allow you to recover this amount. That's just not fair. Now, historically, tort reform, is traced back decades to 2003 was when there were some significant changes enacted by the Texas legislature that imposed caps on non-economic damages in medical malpractice cases. So currently, in medical malpractice cases, you're limited to recovering $250,000 per defendant. So if you're injured by a doctor's negligence or a nurse's negligence or a hospital's negligence, your non-economic damages are capped at $250,000. Now, why is this important? Because this is the system we have, the system of financial compensation for injuries, financial compensation for physical pain and suffering. That's the way that we value these things in this country. That's the way that our judicial system works. There is no other method of compensating somebody when they're hurt. If you, let's say a doctor operates on you and they amputate the wrong leg. The system doesn't allow us to then call in that doctor and amputate his leg. We don't do that kind of justice in this country. We compensate people for their losses. But to say arbitrarily, well, this loss of this leg is capped at $250,000. Nope. I don't think that that's fair. I think that most folks, when they analyze these issues and think about it, will come to that same conclusion. Why should you arbitrarily cut that off? Cut off the cap damages at that limit. I don't think it makes sense. They also impose punitive damages caps. So those are some of the efforts through historically in Texas. Caps on punitive damages. That means that if somebody's repeatedly, a doctor or a nurse or somebody else in an industry is a repeat offender, a company's a repeat offender in a sense, maybe it would be appropriate to impose some sort of penalty that incentivizes them to change their practices. A punitive punishment, a civil punishment, a fine of some sort. These aren't damages that are intended to compensate a victim, but they're damages that are intended to punish those bad actors. And if an act is incredibly egregious and has been going on for many decades, how can you say, well, it's arbitrarily limited at this point? We're just going to put a cap on it. I don't think that that's fair. Now, these legislative efforts they're not done. I mean, there were legislative efforts this year in 2025. There was legislation, Senate Bill 30, that was, fortunately that failed, but that was another effort to extend tort reforms, to limit recoverable medical expenses in personal injury lawsuits, to restrict non-economic damages, or to create stricter criteria for jury instructions. Fortunately, through lobbying efforts of plaintiffs' attorneys and other lawyers, those efforts failed this year, I think well to the benefit of plaintiffs. These reforms are entirely designed in order to tilt the system in favor of corporations and in favor of insurance companies at the expense of victims and at the expense of survivors. Again, why should we arbitrarily limit these damages? If you're injured by no fault of your own, I don't think that the offender should be excused from fixing the damages done. I don't think that that's what we teach our children. I don't think we teach our children that consequences don't matter. If you hurt someone or something, you have to fix it. That's the lessons that we teach everyone in our society. So why do we excuse corporations? Why do we excuse insurance companies from that same sort of liability? We have a system of justice that allows for disputing parties to come together to peacefully present their cases to a jury. And the burden is on plaintiffs to prove their case. And if they do that and a jury awards a verdict, that should be all that matters. Why do we impose a limit that says before a trial even starts, before we even have a case is presented, that a plaintiff can't get full justice, that a plaintiff's pain, that a plaintiff's suffering, a plaintiff's injuries, that their life is not fully valued? That strips away the dignity from plaintiffs who did nothing wrong. And at Ellis Thomas, we oppose all efforts at tort reform. And I think that anybody who's reasonably looking at these efforts would agree with us. And if you're looking for someone who's going to fight, not just in the courtroom, but also in the legislature to try to advocate for plaintiffs, whether they're our clients or not, look to Ellis Thomas because we're there for you.